Discovery is a very big topic. No first-year civil procedure course comes close to covering all of the rules of discovery. The objective here is to give you a 30,000-foot view of what discovery looks like. As you've probably figured out, the process of pleading involves a lot of guesswork. The plaintiff probably doesn't know all of the facts that he needs to support his claims at the time he files his complaint. And the defendant doesn't necessarily know exactly how he's going to defend himself, as he too is missing a lot of facts. They make guesses, usually painting in broad brush strokes. Discovery is the process by which they get the information that they need to make out their claims or defenses and to get ready for trial. Perhaps the most striking aspect of discovery in the United States is that it is conducted by the parties rather than the court. In many countries of the world, the court actually conducts discovery. The fact that the parties do creates for some interesting rules. The general rule is that all parties have access to information that is, one, not privileged, such as by the attorney-client privilege, and we're going to talk about privilege in a minute, and two, relevant to their claims or defenses. It's a very broad standard, and it serves the purpose of ensuring competent litigation by all parties. We want to give them access to too much information, not too little, where we can. There are four basic civil rules, federal rules of civil procedure, that govern most of discovery. 1, Rule 26A, initial disclosures. At a very early stage in the litigation, the parties have to exchange the names, addresses, and phone numbers of every person who might have information that the other party might be able to use to aid their claims or defenses. It can be a pretty big list. They also have to share certain non-privileged documents with one another. Rule 34, requests for production. One party can ask another party to produce documents that demonstrate information that the requester describes. For example, one party may ask to see the other party's canceled checks for a specified period of time. Unless the request to see those checks is inappropriate in light of the nature of the litigation, the requesting party probably will gain access to those canceled checks. Rule 33, interrogatories. A party may ask up to 25 written questions of any other party. The questions have to be specific and may relate to any matter within the scope of the asker's claims or defenses. A pretty broad standard. Rule 30, oral depositions. At a deposition, an attorney gets the opportunity to drill a prospective witness in the presence of her attorney, but not in the presence of judge or jury. It is essentially a practice run so that the attorneys can anticipate what the witness is going to say at trial. A party may depose any person, sometimes even including the other party. Each party has up to 10 depositions, unless they get permission from the court, and typically from the other side, to do more. But you can only generally depose a witness one time. You get one shot at it, and that's it. A couple notes about expert information and expert discovery. Expert data is treated a bit differently from other data. First, let's back up. Fact witnesses, as opposed to expert witnesses, testify about things like whether the light was yellow or red when Marissa's car crossed the line and entered that intersection. Expert witnesses, on the other hand, will testify about things like the quality of Marissa's brakes at the time, the tread on her tires, whether the other side's claims about the speed at which she was traveling are plausible, in light of the information that he or she is able to discern. Rule 26A2 requires each party to disclose the names of their testifying experts at least 90 days before trial and provide the opposing party a report describing the expert's opinions and qualifications. Now, typically, you have to do depositions well before trial. Testifying experts may be deposed shortly before trial. And as I just mentioned, you have to surrender a lot of the testifying expert's information, even prior to the deposition. The rules regarding deposing testifying experts are more lenient because it's widely assumed that experts cannot be effectively questioned at trial due to their superior knowledge of complex issues. Again, the objective is to get more information out than less, and since these people are talking about very complex things that the attorney might not know anything about, it makes sense to give them more latitude earlier in the process. Now I'm going to say a few words about privilege. Communications between an attorney and his client are privileged. This means that no one may compel the attorney or the client to talk about what they have discussed. Indeed, if the attorney voluntarily divulges some of that information, it might be attorney malpractice if it affects the outcome of the litigation. It doesn't matter that the content of the discussions between attorney and client are relative to the claims or defenses of the asking party. Indeed, imagine if the rule were the opposite. The tort victim would be able to simply go to the defendant's attorney and ask the attorney to tell him what happened. If the attorney admits that the defendant actually did beat the plaintiff, the case is all but finished. The proper functioning of our adversarial system animates the entire process of litigation, and it would not be able to function very well if we did not exclude attorney-client communications from discovery. Certain other communications are typically also not discoverable because of privilege rules. For example, communications between spouses are typically privileged. Communications between a priest and a penitent, between a doctor and a patient. In many states, between a psychotherapist and a patient. In some states, even communications between teacher and student are not discoverable. And in some states, a reporter's communications with confidential sources are also not discoverable. Work product. Documents produced in anticipation of litigation are also protected from discovery under the work product doctrine, which has now been codified at Rule 26b3b. It protects against the disclosure of mental impressions, conclusions, opinions, or legal theories of an attorney or any of the attorneys or parties' representatives concerning the litigation. Basically, that means that anything that is written about or thought about and then put into writing in the process of litigation, after it looks like the litigation is likely coming, will not be discoverable. In other words, any written product that's created in preparation for litigation is typically not going to be discoverable if created by the party, one of his attorneys, or one of their agents. While testifying experts are subject to lenient discovery rules, as we specified before, discovery from non-testifying experts is generally limited for the very reason that we limit discovery of litigation work product. Non-testifying experts are closely involved in strategy decisions. That is, after all, why one party decided to bring a non-testifying expert into their discussions. The advice of the non-testifying expert is very much part of litigation, very much part of the preparation for litigation. And the rules permit counsel and party to speak freely to that non-testifying expert.